My name is Liza Goitein. I co-direct the Liberty and National Security Program at the Brennan Center for Justice. And I want to welcome all of you to today's event to mark the release of the Brennan Center's new report, What the Government Does with Americans' Data. First, a few brief words about the Brennan Center and the Liberty and National Security Program, for those of you who may be less familiar with us. The Brennan Center is a nonpartisan public policy and law institute that focuses on fundamental issues of democracy and justice. We have offices in New York. We're affiliated with NYU Law School, and also here in DC. The Liberty and National Security Program works to advance effective national security policies that respect constitutional values and the rule of law. What the government does with Americans' data is the latest in a series of reports by the Liberty and National Security Program, focusing on domestic intelligence gathering. The premise of the report is simple. Since 9/11, laws and policies have been amended to allow the government to collect more information about Americans with less basis for suspicion. Leaving aside whether this is a good way to find terrorists, which is a hotly debated issue, it is certain to result in the collection of large amounts of information about ordinary, law-abiding American citizens. And that begs the question, again, regardless of whether broader collection results in getting more hits, what happens to the misses? What does the government do, and what should it do with all of the innocuous information about innocent Americans that gets swept into the mix? The Brennan Center's report, authored by my colleague, Rachel Levinson-Waldman, sets out to answer this question, or at least to begin to answer it. The report looks at 5 areas of information collection where the standards have been loosened in a way that virtually ensures that large amounts of non-criminal, non-terrorism information will get pulled in. These areas include suspicious activity reports, FBI assessments, national security letters, electronic border searches, and last but certainly not least, information collected by the National Security Agency. Incidentally, before June, that section of the report was a few paragraphs saying, well, basically we don't really know anything. How quickly things change. If you try to Google the rules that apply to these data sets, you won't readily find them, other than some of the NSA rules, ironically. The Privacy Act requires agencies to make certain basic information about their systems of records public. But the Privacy Act has numerous loopholes for national security and law enforcement data. It was a painstaking task and a labor of love at times on Rachel's part to piece together all of the information that's reflected in this report. The report finds that for the most part, the government's policies for retaining and sharing information about Americans do not distinguish between the wheat and the chaff. That is, facially innocuous information is subject to the same rules as information that is suggestive of criminal activity, and it is often held for long periods of time and broadly shared. A case in point, the FBI keeps suspicious activity reports, including those that have been determined to have no relevance to terrorism, for 30 years and stores them in a widely accessible database. In those cases where non-criminal information about Americans is supposed to be treated more circumspectly, various loopholes undermine this safeguard. For instance, the NSA's minimization procedures require the agency to destroy inadvertently acquired communications of Americans as soon as possible. But they may be kept for up to 6 years to see if any exceptions apply. Of course, the retention of data is not inherently a good or a bad thing. Everything depends on the uses to which this data may be put. And so to contextualize its findings, the report examines some of the concerns that flow from the long-term retention and sharing of Americans' personal information. It also examines the evidence for and against the argument that retaining more data enables us to be more effective in detecting terrorist plots. I'm not going to delve into the conclusions that the report comes to on these issues because I don't want to steal the panelists' thunder. And for the same reason, I won't go into the recommendations for reform that are contained in the report. I'll let the panelists talk about those. So with that, let's hear from the experts. We are extremely fortunate to have Julia Angwin as our moderator. Julia is an award-winning investigative journalist at the Wall Street Journal. In 2010, she led a team of reporters that chronicled the decline of online privacy in a series of articles titled What They Know, which won the Gerald Loeb Award. In 2011, the coverage generated by her privacy team was a finalist for a Pulitzer Prize in explanatory reporting and won the Sigma Delta Chi Award from the Society for Professional Journalists. She's the author of the 2009 book, Stealing MySpace, The Battle to Control the Most Popular Website in America, and has written another book that will be published next year entitled Dragnet Nation, A Quest for Privacy, Security, and Freedom in a World of Relentless Surveillance. I should add that those of us at the Brennan Center who work on issues of data privacy are indebted to Julia for her incisive reporting in this area. Julia?
Thank you very much. Is this on? Can you hear me? So thank you very much for such a kind introduction, and it's a real honor to be here to to introduce this report. But first I want to introduce the panelists. So you have their bios in front of you. They're all luminaries. So I thought I would just give a short introduction of who they are to me. So Rachel Levinson-Wellman, who's the author of the report, I first met her about a year ago when she was starting this report and I was starting my book. And we had this incredible meeting where she convinced me that indiscriminate surveillance of innocent Americans was really the topic that I should focus on. And that's actually one of the main reasons that my book is Dragnet Nation, about indiscriminate surveillance. There's a lot of surveillance out there, but you know, you and I could be wearing Google Glass and surveilling each other, but indiscriminate surveillance by the government and by commercial entities is a topic within that world, and I think she did an amazing job of capturing it in this report. She comes to this work through a background in defending academic freedom, and is now counsel to the Brennan Center Liberty and National Security Program. Next to her is Julian Sanchez, who's a research fellow at the Cato Institute, who writes about privacy and technology. Like most people, I first met Julian on Twitter. He's a very strong presence on Twitter. And what I've learned over the years is that Julian has this incredible ability to have the mind of a lawyer and a philosopher with the twitchy reflexes of a journalist. And the combination makes for some fun writing, and it makes sense that he has a background in journalism and in philosophy. And finally, Laura Donahue, who is the only one I haven't met personally until today, but when I was reading her bio this morning, honestly, it scared me. I'm just going to give a little excerpt. She is currently writing on drones, war power resolutions, biometric identification, extended detention and interrogation, biological weapons, and the history of quarantine law. Now, how does this woman sleep at night? So, but then I saw that her most recent book was on an even more terrifying topic, the cost of counterterrorism. How much are we really paying for all of this? So anyways, it was great to have a great panel here, and I thought that I would kick it off with probably the most controversial recommendation that you make in this report. What I love about this report is this narrow focus on innocent Americans who have been caught up incidentally and are not a target of an investigation. And you make what seems like a pretty easy ask, which is, maybe we don't need to keep that stuff, right? Maybe we should throw it away. And you know, in that very limited context, it seems like a reasonable question. And you, specifically, your recommendation is prohibit data retention in absence of reasonable suspicion, and then also further limitations on sharing that data, particularly on if it's protected First Amendment activities. And this is something that I've noticed in my reporting, is that this is something that really bothers people who have been caught up in indiscriminate surveillance. So a recent case, David House, whose computer was seized at the border and copied, and he was never charged, but it was interesting that what he wanted in his legal settlement was his data to be deleted, right? He wanted to be out of the net. And a guy that I'm writing about in my book, Yasser Afifi, was tracked by a GPS device under his car. When he found it, the FBI came to reclaim it. And what his lawsuit is seeking is, I want my data deleted, right? There's something really primal about this for people who have been surveilled. They want that data gone. If they're not being charged with a crime, they don't want to be have a dossier on them forever. So, since we don't have a representative of the government on the panel, I'm going to play the devil's advocate, though, and pose the question that people who defend this data retention would have, which is, they say, you never know, right? One day we might need this. And certainly I know this. I'm very bad at deleting old emails, right? One day I might need them, even though I don't really need them. And so I understand this is a very human feeling. I'm going to read a quote that when I wrote an article about the National Counterterrorism Center's data retention plans for retaining vast databases of innocent Americans in order to constantly rescan them for terrorism clues, what they said to me, and I think this kind of encapsulates the position people take, what we learned from Christmas Day, which was the underwear bomber, was that some information might seem more relevant later. We realized we needed to retain it longer. So I want to ask all of you, but starting with you, Rachel, how do you address that argument? Because that seems to be the key question here.
Right. I think it's a great question, and it's certainly something that we talked about while we were looking at this issue and thinking about the recommendation. It's so interesting to me that one of the examples that the NCTC cited was the underwear bomber, because one of the things that we know from the White House review of that, so I think as most people know, there was this bombing attempt that was averted through basically luck. And one of the things that came out of the review of that was that one of the elements that had stood in the way of actually this plot sort of being put together before he even got on the plane was that there was actually too much information in the system. Not that there wasn't enough, but that there was too much, and that sort of that huge mass of data was making it much harder to actually analyze the important parts. So I think that's one of the answers. The other answer, in some ways sort of harkens back to 40, 50 years ago, which is the risk of abuse, right? You have lots of information that seems like it might be useful in the future. But as a fundamental matter, that's not how our government works. It's not how the Fourth Amendment works. You don't get to sort of take lots of stuff in, especially personal information, communications, First Amendment protected information, sort of because somewhere down the line, maybe it's going to be more useful. And so we thought about this in terms of what are the risks for abuse, and also sort of how, from what experts say, how does law enforcement work best? How do investigations work best? And the answers seem to be having that work be much more targeted.
Right. Julian, do you have something to add on that?
I think all that's right. I would also note that just the plausibility of the time frame on which this is the case is maybe 2 years, 3 years, plausible. 30 years in the case of some records. It's very hard to imagine what the intelligence value on that time frame would be. I also think there's a kind of weird framing effect here. Right, cognitive psychologists talk about a kind of cognitive bias called loss aversion, where right, if you say how much would you pay me for this cup, they'll say, well, $2. If you say, here's the cup, it's yours now, how much do I have to pay you to give it up? They'll say, oh, $8. And I think something similar sort of happens with data. No one says, my God, all these phone calls are going unrecorded, we'd better tape them all because we might need them later. It's only when, as increasingly is the case in modern communication networks, something is even ephemerally recorded for a second, that its erasure is seen as a loss and therefore as somehow unacceptable. Whereas, I think we just ordinarily accept that some kinds of data are ephemeral. If they're not recorded at all, you just miss them.
Laura?
So I actually want to go back to the Constitution on this. So usefulness for me is never a sufficient argument for a reason to do something, because it would be very useful, for instance, to collect everybody's information 24/7, 60/60, and to have it at instant recall. But at the founding, those were called general warrants. The British government used them to crack down on illegal behavior, and it was for this reason that we have the Fourth Amendment. It was specifically constructed to prevent general warrants, which allowed the British government to basically search at any time and to collect information on individuals, and then to take that information and to analyze it subsequently. Now, the argument in counter to this is that in 1979, there was a very important case that was handed down through the courts called Smith versus Maryland, where a pen register was placed on an individual's phone, and the court said that you have no privacy interests in information you voluntarily relinquish to a third party. So when you make a telephone call and the telephone company picks up that telephone information, you don't have a privacy interest in that. It's not covered by the Fourth Amendment. So all your telephony metadata, for instance, under the Foreign Intelligence Surveillance Act, the use of Section 215 that we've been seeing, the argument runs that this is not constitutionally protected. And the problem that I think the Constitution has with this is that, in fact, the kind of information that you're revealing to the phone company because of new technologies is much more than you intend. So from your telephony metadata and from the trunk identifier information, the government can tell where you're speaking, where you're located, who you're calling, where that person is located. They can tell how long you talk. There's substance if you call a rape crisis line or a suicide hotline or some sort of a support group, your clergy. They can tell how long you speak. So there's substance that's conveyed in that as well. And with many of these new technologies that we're seeing, there's actually a lot of information. So the question of retaining the data and how long we retain it, that retention is what allows it to be combined with biometric and biographic information. And in that process, new information gleaned, a knowledge generation. And that is a different level of intrusiveness in terms of privacy than what we've hitherto seen. And right now there's tension in the court. So the court has kind of divided along the lines over whether this is a trespass, new technologies are a trespass on the individual, or whether it should be considered under the Katz's definition of a reasonable expectation of privacy. So we saw, for instance, with thermal imaging under Kylo, a case which dealt with marijuana, that the court was saying, well, if you use this kind of intrusive technology, is there a trespass that occurs, or are you invading somebody's reasonable expectation of privacy? The same questions came up with GPS chips in the Jones case that recently was handed down, dog sniffing this year with Jardines, and the court divides. The problem is that regardless of whether one looks at it as a trespass or as a reasonable expectation of privacy, either way, the retention and analysis of all of this information, I would argue, does violate the Fourth Amendment.
Well, if it's proven to violate the Fourth Amendment, then we don't need your recommendations. It's just be illegal, and we can move on. But currently, we're not in that situation. I want to raise, though, in my role as agent provocateur and stand in for the government side of things, I want to raise the question that always comes up in these debates. Well, what is the harm? Okay, your data's in there, they're scanning it, but you're not a terrorist, you didn't do anything bad. Get over it, right? This is the get over it crowd. And you know, when I was talking to the National Counterterrorism Center people, they said, you look, for technical reasons, it's much easier to have the data in-house and do these structured data queries, and, you know, but we're not actually, like, nobody's really looking at it when you're innocent and this and that. So let's go straight to the harm question, because that's the question you always have to answer in these debates.
Should I take this one first? Sure. So I think there are, not surprisingly, I think there are a lot of harms, and I'll sort of walk through what I think those are. The first is to go back to something that I'd mentioned briefly before, which is the idea of abuse. This is maybe the most obvious one. I sort of alluded to, you know, in the 70s, the Church Committee report comes out. It turns out that the FBI, the CIA, the NSA has been gathering huge amounts of information and has been using it to target political enemies, to target minority groups, to target social activists. And you see some of that even much more recently, right? So we haven't had a recent church committee, but there are kind of bits of that we've seen coming out. There was a 2010 Department of Justice Inspector General report that said that the FBI sort of similarly had been opening investigations without much what's sort of called predication, without much kind of reason to believe there have been criminal activity, mostly targeted at people who were in fact engaged in political activity. They kept these investigations open for too long. People end up on watch lists. So I think we always have to be cognizant of in fact our history, that it's not sort of this specter out there, but that the history of collection and especially retention of information is this risk of abuse. So that's one. I think another is sort of what we think about as a classic chill on First Amendment speech, that if you know that the things that you're saying, whether it's in public, whether it's whom you're associating with by virtue potentially of location information being gathered, whether it's the content of your communications, who you're talking to, for how long, there's so much information that's being gathered, what you're buying, you name it. That if that information is known, then people will start censoring themselves. To the extent that there is any kind of governmental censoring instinct, to some extent, I think the people take over themselves if you know kind of how much information you no longer have control over. I'd say a third risk is just a fundamental privacy issue. I think there are people who feel, I think a lot of us feel, that there are things that, we're doing that aren't wrong, they're not illegal, they may or may not be against social mores, but we just prefer to keep them private. And so I think there is a risk to having that information sort of out there, and again, something over which we have very little control. And the last thing that I'll say, there are a couple more things I could add, but I suppose the other is that there are things that aren't illegal now that could become illegal in the future. And one of the things that we see, one of the patterns that we see across a whole variety of areas, and biometrics, which Laura has done a lot of writing and reading in, is originally think about things like DNA. Originally DNA was taken only from people who were convicted of sexual offenses or other violent crimes. Then that expanded to people who are convicted of other offenses. Now it's anybody who's arrested for certain kinds of crimes. And so you think about this expansion of use of information, and at the same time kind of various shifts in criminal laws. And so you think information that's taken in now can always be used for other purposes down the lines. And I think that slippage is a really significant risk as well.
There is one kind of, before you, Julian, I just wanted to say there's this amazing thing in here, the Maryland surveillance, the mission creep, which you're talking about. So they started off surveilling some, well, it's not clear that there was any real reason to surveil these people, but some activists in Maryland, the state police began surveilling them, and then eventually got to this point, you guys all should really read this on page 14 at some point, that they weren't finding anything. They didn't charge anyone with anything. And eventually they got a hot tip that the animal rights activists might steal a chicken from a local chicken farm. And so they sent an undercover trooper to the PETA meeting, the People for Ethical Treatment of Animals, to see if anyone talked about chickens. And they did not. And this is to me, this is the perfect example of the slippery slope of mission creep.
Indeed.
Start off possibly with some legitimate reason, but eventually you're trying to find chicken crimes before they're committed.
Right. And that, in a lot of ways, was an attempt to justify the resources that had originally been put into what seems to have been a fairly illegitimate surveillance in the first place. They say, well, we've already tasked somebody, we've already spent this time, we have to come up with something, right? And so then they get deeper and deeper into it.
Right, and then somebody has to go to jail for chicken crimes, I guess, at the end of it.
Right, well, and in fact, what happens to sort of play out this story is that my recollection is that nobody was found sort of quote unquote guilty of anything that's happened, but what happened was that people were in fact put into federal databases, kind of tagged with labels that made no sense, and it was largely because of the software that they were using. So there were kind of quote unquote terrorism crimes that were related to things like animal rights. And then it's unclear if that information has ever come out of some of the federal databases that it ended up in.
Right.
Yeah.
It reminds me that my favorite story about really long-term data retention. My favorite example of this is in 1942, Inga Arvad, who was a columnist for the conservative Washington Times-Herald, was put under surveillance because I think FDR basically suspected she might have German sympathies. And so she was wiretapped, and the wiretaps picked up evidence of her affair with a young naval officer named John Kennedy. This is 1942, and because of the sensitivity, she was a columnist for a newspaper, these were filed under a sort of special protocols. And instead of going into the main record system, they went straight to a private file in Assistant Director Lewis Nichols' office. And so they stayed there for 18 years, until on July 13th, JFK wins the Democratic presidential nomination. On July 14th, the enormous file on Arvada and Kennedy is suddenly moved directly to Hoover's personal confidential file in his office. So it always pays to keep stuff around. You never know. On harm, I would just say two things very quickly. One is that I would actually question whether we should be exclusively framing privacy violations in terms of harm, as though that's the only sort of legitimate language in which to discuss them. Right? You can imagine a hospital orderly who's taken to fondling comatose or heavily sedated patients for sexual gratification, and you kind of in a crude utilitarian sense, you could say, well, if no one ever finds out about it, if the patient never finds out, is there a harm? And obviously there are things you could say about possible harms or systemic harms, but at some level I think the right answer to that is, well, I don't need to show a harm. That's just a sort of affront to the dignity of the person and an invasion, and I don't need to specify an additional harm. It is a wrong in itself. I don't want to make the analogy they're too strong to collecting metadata, but there are things that are invasions and affronts to human dignity, whether or not there's a harm. And I would add one more kind of architectural harm to all the good the sort of salient points Rachel made, which is just that there is a kind of architectural harm of what the anthropologist James C. Scott calls legibility. The more legible a population is, the more the horizons of control are changed in a way that makes new proposals for control possible that were previously unimaginable. So when you think of the internment of the Japanese, again in World War II, the fact that we had databases showing where people lived and what their ancestry was made that possible. It doesn't mean we shouldn't conduct a census, but that is an option that would not realistically have been on the table but for the legibility of the population in a way that enabled that decision to implement that system of control.
So I'd like to respond to both the specific harms that Rachel mentioned as well as the more generalized harms. I'd like to kind of respond to both of those points. On the more specific harms, certainly you mentioned basically a First Amendment chilling of free speech. And the problem in terms of pursuing that in the courts is that you're subjected to strict scrutiny. So you have to have a governmental interest that outweighs that harm. And national security is the ultimate governmental interest, right? So I actually don't think challenges on First Amendment grounds would succeed because national security goes to the very heart of what it means to have a government, and I think that often that would defeat a First Amendment claim. The Fifth Amendment due process point, although you didn't raise it, you could possibly challenge these on Fifth Amendment grounds, Fifth and 14th due process. The problem here is that the more information you get, the more accurate you are, right? So actually multimodal biometrics would make you more immune from Fifth Amendment challenge than having just DNA, right? So if you have DNA and gait technology and hormone sniffing and by the way, facial recognition technologies, then you're not likely to succeed on Fifth Amendment due process grounds. On Fourth Amendment grounds, I think that there is a colorable argument to be made, especially under Jones and the shadow majority, that even applying CATS, the CAT standard and not the trespass standard, that you might succeed that these are invasive technologies and you can challenge them. But if there is reasonable suspicion or higher, then I think that you're on weak ground in the Fourth Amendment type claims. So driven back to more generalized harms, to continue on the question that was posed, there are two that I'd like to mention that don't often get attention. First is the impact on democratic governance, this idea that when we talk to each other about political matters or scientific matters or religious matters, this goes back to William Penn and the founding of Pennsylvania and the colony of Pennsylvania, that you want to have this open discussion. You want to be able to talk where everything isn't actually recorded, because through that exchange of ideas, you're more likely to have an informed, enlightened, and forward-looking citizenry. And I think that's a very important fundamental principle in the United States, that you have the freedom to do that. And because of that, we can all vote, and we then have the ability to take part in that electorate and in that process of making decisions as a country. And I think that's a very important part of American democracy. The second and final generalized point that doesn't get attention, and this, frankly, is a concern I have about technology writ large, this is the scarlet letter concept. So Hester Prynne children, was able to move, 3,000 miles to Massachusetts, and in that capacity rebuild her life and kind of create a new persona. I wonder the extent to which our children, and certainly our children's children, will be able to do this. That in some sense, if everything they do is recorded and held online, regardless of whether it's held by the government or society at large, and they're unable to expunge the record, then everything they do from when they were born, forward is now memorialized. How do they then recreate themselves? How do they break with their past, decide to become somebody new, or does this always follow them throughout their lives? And I think a lot about this in terms of thinking of how do we create a society where people can leave things behind? Are we going to become more tolerant of deviance? If I think back to things that I did in college that I'm not particularly keen for my children to know about, I find myself already editing out, like certain versions of my life because I don't want them to repeat my mistakes. Have we created a society, and are we creating a society where people cannot make mistakes, or you create two kind of classes of people, those who are able to go through society without these recorded, and those who, everybody else, who it records it. And I've seen my students been denied jobs because their employers have gone on their Facebook pages and saw what they did at spring break, down in Florida. I've seen in class ways in which interactions between students have changed at the law school because they're afraid that what they say will be put on Facebook and pilloried subsequent to the conversation. And I see people afraid of taking risks and really living their lives because it will then follow them, and others who haven't thought about that who now are being denied jobs. And so I have a broader question in my mind, and it isn't just about government surveillance. It's about the extent to which technology limits our capacity as human beings to become fully human and to decide who we want to be in the future.
I was just going to add, of course, there's a very interesting article that very much relates to this a couple of days ago in the New York Times about companies, and again, here we're talking about companies and not the government, but there's this intersection that are taking mugshots, right, and posting them online and then charging people to have them taken down. These are mugshots from arrests. These are people who haven't been convicted of anything. And so it's the same thing. You Google somebody, you look for them. I think they, cited somebody who had gotten arrested for something in college. He had worked it off through community service. But, half the hits on the first page, if you Google him, are this mugshot from an arrest. And so, is it okay that he has to pay to take it down? Can he afford to take it down, to pay to take it down? And that's really sort of a fundamental interference. But then you have some potential tension, at least I think some are saying, with First Amendment interests in terms of being able to publish information. And so sort of how do you resolve those?
As part of my book, Dragnet Nation, I tried to protect my privacy and the privacy of my children, and I was really stumped by the Scarlet Letter issue, and until I realized that there was only one answer, which was to create fake identities for my children. So they have fake identities online, and I've actually already taught them that they're going to dispose of them every 3 years. So because when you go from middle school to junior high school, you're going to need a new one because you don't want everyone to know how uncool you were, right, in elementary school. So the thing that was sort of disturbing to me as I sort of played out the counter strategies to the world we live in was it's sort of fun and a joke, but it's also like, do we want to live in that world where everyone has like 100 fake names? And I also have some fake names also. You'll see them in the book. It's fun, but it's a weird way to live, right? It's like it's forcing people into strange boxes, but they love their fake names.
That's really great.
So, anyways, I wanted to follow up on your point, though, about the Scarlet Letter and about the limiting democratic debate, because I would say, aren't those both First Amendment? They are First Amendment issues in some ways, right? There's some. It seems to me you can't wall off the first. I mean, I know there's a real narrow reading of the law, but certainly as what the founders intended was to build a society where we could have vibrant political debates. So I would just argue maybe that there's possibly, even though the courts haven't read it that way, there's a broader moral First Amendment argument there.
For what specifically?
For the fact that your two harms, which was the limiting democratic debate and the Scarlet Letter issue.
Yeah, but in order to show that you have standing, you have to have particularized harm.
Agreed.
Right, that has
I'm
occurred,
not saying the court has agreed that,
Yeah.
but I think that if you got
I think it's a
rid-
judicial matter. It's
Yes.
kind of a non-starter.
Right.
We're very difficult. It's an uphill, but it's a Sisyphean task in some sense.
Yes, exactly. But you also raised a good point, which was about the national security exemption, which will always trump, will always happen, right? So in your other recommendations, you talk about the Privacy Act being reformed, but as I asked you yesterday, I mean, my jaw dropped. I was like, is the Privacy Act going to apply to the NSA? I can't imagine having the right to see my NSA records or correct and dispute them. Right. And so I wanted to see if you could talk a little bit about your Privacy Act recommendations, and then how would the NSA issue be addressed or not in some other way?
Sure, that's a good question. Oh, yeah. And actually, before I get to that, I do want to say one other thing about the First Amendment issue and the national security trumping, which is that I wonder, and again, understanding, you know, it may be hard to get over standing hurdles, but I wonder if now that we're finding out more and more about the effectiveness of some of these programs or lack thereof, so especially you think of the phone metadata program, that it seems to have been pretty clearly acknowledged that when you talk about sort of quote unquote threats to the homeland, there are not that many plots to which the database has been relevant. There are one, maybe two, to which it's sort of been a but-for contribution, and at least one of those didn't actually pose any harm. It was a matter of giving money. And so I do wonder if as more and more of that information comes out, I don't know, will courts start to be somewhat more skeptical about the invocation of the national security kind of justification? Maybe not, but it strikes me that that could be one outcome of the fact that there is more transparency now about these. And I don't know if I should move to the Privacy Act or if there's anything else that Laura wants to say about that.
Courts tend to be fairly deferential for national security matters. So say state secrets, for instance. There are hundreds of cases over the last decade where the courts have allowed the state secrets defense to come into play, where contractors were involved, car crashes in the green zone, patents and copyright issues, environmental degradation questions. And as soon as a contractor gets the government to support a state secrets claim, the courts will be deferential to the point where they'll pass 20,000 pages as being classified and say, okay, state secrets, we're not going to look into all 20,000, but surely at some point there's national security information involved. So from the state secrets studies that I've done, I've been surprised at how deferential the courts are when national security interests are invoked. As a matter of First Amendment, you know, national security is the ultimate offsetting in strict scrutiny. If it is for national security purposes, it's very hard to overcome that hurdle. I don't think it's impossible, but it's a high hurdle, and certainly the case law goes against that. For instance, taking photographs of crowds, it dates from the 70s, when there wasn't this instantaneous recognition of who was in the crowd. They could take a picture of a protest, a war protest, and then they could go away, figure out who the person was. That's where the case law is on this particular issue. So I don't think it's impossible. I just think it's far less likely than a Fourth Amendment type challenge, where in the shadow majority in Jones, you have the court expressing unease with 24/7, 60/60 surveillance using a GPS chip for 28 days, with the idea that this would somehow represent a different kind of invasiveness and a level of privacy that's implicated that wasn't previously the case with just a pen register under Smith versus Maryland.
Which adds, and this is something I think Dan Solov has pointed out pretty well, which is that there's this sort of strange asymmetry in the way this balancing test works, right? When they're weighing the national security interests, it is the interest in national security as a whole. So, like, you know, so the downside here is total failure of national security. The republic is flattened by nuclear weapons and turned into a smoldering Mad Max wasteland. Not you know, what is the marginal contribution to the reduction of national security risks of this particular program, but the national security interest. And then you get to you know, sort of the civil liberties side of it, and notwithstanding the sort of explicitly collective language of the Fourth Amendment, it's you know, what is the privacy interest of one phone record for one person being collected, and never mind whether it makes a difference if it's you know, decades of phone records on everyone. So I mean, just obviously national security is always going to win if that's sort of the approach.
So I also want to mention, recently we've had a number of decisions declassified from the Foreign Intelligence Surveillance Court dealing with Section 215 of the Foreign Intelligence Surveillance Act. And in one of these opinions in March 2009, Judge Reggie Walton actually said there is no way you could collect bulk information on telephone subscribers under the law. There's no other way you could do this. But because you swore under oath that this was vital for U.S. national security, we let you do it. And we gave you minimization procedures, which you did not follow. They requested that the NSA engage in reasonable articulable suspicion analysis prior to running inquiries against that database. For almost 3 years, they did not do it, right? And when the court found out, they were very upset. But the reason they were very upset is because they said, look, there is no other way you could get this information, which, by the way, violates the statute because the statute says you have to be able to get this under subpoena ducis tecum. So that's one thing. But then he said, but we let you do it because you promised it mattered for national security. You swore under oath is the exact language. And then it turns out that they couldn't come up with any substantiation of instances, not sufficient for the court in that instance. So I don't think it's impossible for courts to look at it. What's interesting to me is that for 3 years, Fisk let them do this secretly without actually inquiring deeper into whether there was the more substantive benefit in terms of national security.
Yeah, which I think that's fair. I do wonder, though, there's so much public pressure building up on this issue. I wonder, and maybe it's partly just that I hope, but that courts will be a little more skeptical, will ask somewhat deeper questions. I think very much going to Julian's point, going to the larger issue of, is something crucial for the aspect of national security that it was developed to assist versus some of the First Amendment interests. And I know that the case law, the current case law doesn't get us there, but I do wonder some of the effect will be to kind of heighten some of those questions that the courts may not be asking right now.
But maybe we should table Privacy Act and just go to oversight and then come back to Privacy Act.
Sure.
Because we're so close to oversight here right now. Sure. I think that the Fisk decisions, of course, raise the question, what is the oversight? Is it just you go to court and you say, I promise to be a really good person, and that's oversight? Or what kind of oversight are you asking for? So I wanted to have you lay out your oversight provisions, and then I wanted to have Julian, I'm just going to tee this up first, explain why he said the watchdogs have all become lapdogs.
Sure. So in terms of oversight, you had asked about FISC, the Foreign Intelligence Surveillance Court. We actually didn't talk much about FISC in this report because it is fairly specific to the NSA and to certain things that the FBI was doing. And obviously we're addressing broader issues, and especially because we were addressing the retention piece and not collection. We don't talk as much about FISC. Certainly, I think there are a lot of proposals that have floated around about having a more adversarial aspect to FISC, and I think those would be enormously useful. It's actually something else the Brennan Center is working on right now, sort of looking more deeply at the court and how it might be reformed. In terms of oversight, I mean, I do think the Privacy Act oversight actually is a piece of this, and I can talk about that now. We also talk more generally about, it's kind of a combination, I would say, of some congressional oversight, some kind of agency oversight of its own, and then potentially public oversight. I think the oversight piece is kind of an umbrella, actually, for a lot of the recommendations in the report. So we recommend that the policies about how agencies use, keep, share Americans' information be much more transparent, be much more easily available, and that especially the policies about kind of where that information goes. So an agency gets it in, but then is it sharing it with another agency? Is it sharing it with a foreign government? Right now, a lot of that information is very opaque. It is very non-public. There are memoranda of understanding somewhere out there that nobody really gets to see. And so I think having those available and easy to find, I think would assist in kind of the public oversight of what the government is doing with people's information. I do talk about the Privacy Act, and I can go more into the details, but one of the things that the Privacy Act was meant to do was, in fact, to impose some control over how government agencies were gathering Americans' information, what they were keeping, and also to give people kind of a right of access to their own information and a right to challenge what an agency had. There are loopholes to that. There are law enforcement exceptions. There are national security exceptions. And the ways that agencies can kind of invoke those exemptions, there's just very little oversight over and it's kind of an entirely agency-driven process. And so then another aspect of oversight is potentially having an independent board that would oversee that process, that might impose some controls, kind of in collaboration with Congress, and that would also kind of require more reporting from agencies in terms of what they're doing. And then there's an oversight piece. This is sort of a fundamental and almost too obvious thing, but much more regular audits. It really varies by agency. kind of what we know about how information is used. And so having that be a more transparent process, a more public process. And then we also talk about oversight over the National Counterterrorism Center, which I know you had mentioned at the beginning. But it's, it's an agency, a body, a center that takes in and can take in huge amounts of terrorism and non-terrorism related information. But there's not a lot of transparency about exactly what it's doing, and especially, and we were talking before about effectiveness, it used to be that it could take this information in and hold it for 180 days. It basically had to get rid of non-terrorism information about Americans immediately. Now it can keep it for 5 years if it meets certain criteria and sort of keep searching through it. But as far as we've found, at least, there's been certainly no public study about whether that's necessary, why there was the jump to 5 years. The more that we learn about other national security programs, has that actually contributed to national security? So that's a fundamental oversight aspect. And then the last piece, which we talk about a little bit, is, again, going back to the intelligence context, which is much more aggressive congressional oversight. I think that's been for people who've been following this, that's really been one of the most kind of shocking and just disappointing aspects of the last few months, is finding out the extent to which some members of Congress have said that there's been very rigorous oversight, and certainly the intelligence community has been touting very rigorous oversight, and that we've found that in many ways that's not true, that members of Congress are withholding information from each other, and there's limited information that Congress is finding out, but the fact that maybe a few of them knew is then being used as justification for their having ratified entire programs. And so I think really beefing up that congressional oversight as well.
So I guess I'm a little more pessimistic. I just question whether oversight scales to the magnitudes that we're talking about. If the NSA people are choking on the data, drinking from the fire hose, whatever metaphor you like, then sort of a fortiori, the oversight folks who are doing this as one small piece of what they do without incredibly sophisticated analytic algorithms. Just on the FBI side, it's a very targeted FISA surveillance they do. I think there was a 2008 IG report that said they had about a century backlog. I mean, meaning 100 years worth of audio of untranslated, unreviewed recordings. So the problem here is that they themselves don't know everything they have. And they're doing millions of queries a year, and then you're asking an overseer doing an audit on a tiny sample to be checking their work effectively when, again, as we learned from one of these court submissions, even the people who were building the system for the phone records database did not understand in detail how that system worked. And so you end up basically, I think, with trust as a proxy, right? If the FISC and the people building the system don't really understand how the system works, does Dianne Feinstein in the few hours of briefing she got where she couldn't take notes or have cleared staff? I guess is no, so you end up with basically trust as a proxy. Do these seem like good people? And unsurprisingly, in a system like this that depends on self-reporting, what you're going to find is the accidental violations that people admit. So it'll seem like, oh, we're finding only a lot of accidental violations. It's like this is sort of the Stephen Glass problem in journalism. You've got a fact-checking system that's going to catch a lot of errors. It's not going to be very good at catching deliberate violation because a violator knows how to game the system. And so you end up with overseers seeing some small incidental-looking violations, not serious-looking abuses, and so it becomes a trust relationship rather than a kind of data-based analysis. And then over time, as you are an overseer keeping these secrets, even if you have reservation at first, I think you become complicit in keeping the secret, and much as having spent $1 million on something, you want to try and justify the program. Having shielded the secrecy for so long, you want to justify the secrets you've been keeping. And so we see the nominal overseers time after time telling us pieces of the puzzle, telling us about all the rigorous oversight, and then not telling us the things that they know about how that system broke down. Because they're very sure it's been fixed. I think it sort of calls into question the effectiveness of that mechanism as a meaningful check.
So I'm a little bit more optimistic in some sense. And the reason why, it couldn't be less, yes. There's that, right? No, I'm more optimistic because, so for instance, it was the Inspector General reports. You know, Bart Gellman reported that the national security letters were being used about 30,000 per year. When the IG looked at it, of course, the number was 50,000 NSLs were being issued per year. And by the way, there were exigent letters, which is a letter that said, oh, we're about to apply for a warrant, which of course there never was a warrant, and so on. And by the way, there were also this post-it system where where the CIA would be sitting next to the telephone company operators, put a post-it, say I need these records, they would deliver them. So the Inspector General actually went really far and did a really remarkable job on NSLs. Almost everything we know about NSLs is because the IG reports that have come out, and there have been 3 now that have been very important, and they've been very hard on how NSLs were used. It was the Department of Justice, the National Security Division, when they met with NSA, that found out in January 2009 that RAS, reasonable articulable suspicion, was not being applied to the bulk metadata set, and they reported it to FISC within a week, right? So I actually see a number of instances where the oversight mechanisms in place have been particularly effective at telling us what has been happening. With that said, I think there are a number of ways that it can be improved. So for instance, having an opposing counsel at FISC, at the Foreign Intelligence Surveillance Court. We have found out that the Foreign Intelligence Surveillance Court has carved out an exception to the Fourth Amendment under the special needs doctrine, that foreign intelligence is a special need and therefore not subject to Fourth Amendment protections, with no opposing counsel to actually represent something different. So when this August of this year, 2013, Judge Egan released her opinion, declassified it. She only discussed the Fourth Amendment in 3 double-spaced pages, and the only 2 cases she directly referenced were Smith versus Maryland and a FISC opinion that's secret and classified and we still can't see. So that's a certain amount of self-referential behavior that goes on if you don't have an outside counsel. So however hard DOJ and others might be trying to represent different sides and to do due diligence, and we see wonderful examples where this due diligence really was very important, I think that there is really no substitute for having an opposing counsel. That's how our system has been established. So I think that could be introduced. The Privacy and Civil Liberties Oversight Board, giving them subpoena authorities. That would change the system. That would actually give them some teeth and an ability to conduct better oversight. Statutory changes. So the Electronic Communication Privacy Act doesn't apply to video recording. The circuits all agree on this. The Ninth Circuit, Judge Alex Kaczynski, who's the chief judge of the Ninth Circuit, will not apply ECPA to silent video recording because it's not in the statute. Other circuits say, well, we'll read it in even though the statute doesn't apply. Privacy Act changes, SORNS changes, like all of these could actually be updated to take account of these new technologies that are emerging. The final shift that I would really strongly recommend as a way to deal with oversight is narrowing definitions. So right now under Section 702 of the Foreign Intelligence Surveillance Act, the government can intercept any electronic communications, not just related to foreign intelligence, but under the second part of the definition, related to any foreign affairs. This means that every international conversation that anybody has in the United States can be intercepted, kept, and then subsequently analyzed depending on the minimization procedures that are put into place. This is an extraordinarily broad authority. By narrowing that definition, you actually get more careful oversight. By creating special protections for U.S. persons, you get better oversight. Similarly, national security. I've just finished about a 140-page law review article on how the concept of national security has shifted over time and definitions legally adopted by the United States have shifted. Right now, we're in a great period of expansion, which makes it very helpful to break bureaucratic gridlock, but very hard to tie these powers down and to kind of narrow them and use them where we need them. We need them to be able to respond to very real threats that the nation faces. We probably don't need them for chicken incidents, in Maryland. So how do we look at the definitions that we use in a way that allow our intelligence agencies, and the government that's doing a job of trying to protect the country, how do we narrow it in a way that allows them to do that without unduly interfering with the privacy rights of individuals in the United States?
Two
I
just
think you
quick
should
points.
finish up and then we should go to questions.
Okay,
So,
sure, that sounds good. So I think both Julian's and Laura's points are well taken, and it's funny, while Julian was talking, I was writing down OIG reports and DOJ lawyers involved in NSA work. So I totally agree with Laura bringing those points up. I would just add 2 quick things, and one is that I do think in a lot of ways we're focusing on the intelligence work, and it's hard not to because it is it is the elephant in the room. It's what we've been reading about. It's sort of some of the most stunning revelations we've heard in a long time. But there is also the more sort of general law enforcement piece. And so I think I would just add two quick things on that. And one is that, Julian was talking about, to a large extent, there's information coming in through intelligence work that nobody's ever going to see. It's sort of masses of communications that are sitting there. And obviously we've talked about the fact that there are issues with that, but that as a practical matter, still, nobody's ever seeing it. To some extent, nobody understands it. I think that's less true with some of the other authorities that we talk about. So we haven't talked about these in as much detail, but Liza mentioned them, Julia mentioned them. So things like national security letters that the FBI uses to get information. The standards were lowered for those quite a bit after 9/11. That information can be kept for 20 to 30 years. Information that comes in through assessments, which are these very low-level FBI investigations. For those, we're not talking about the same kind of bulk collection. This is something where somebody is going out and gathering reasonably specific information, but then keeping it regardless of whether it relates to an investigation. So with that, I do think somebody knows it's there, somebody's seeing it, and conceivably somebody could make a decision not to keep it for 30 years just because it might be useful in the future. And the one other point that I'd make, obviously we talk about the PCLOB, the Privacy and Civil Liberties Oversight Board, and I agree, I think having subpoena authority would be huge. In some ways it's hard to know how that board itself with its staffing could sort of do everything that it would need to do or be able to do if it had subpoena authority, but I do think would be very useful. And then again, the one thing to add is that the PCLOB focuses very specifically on counterterrorism laws and regulations, and it can't look at sort of the more generalized law enforcement piece, which I do think is also a very important aspect of what we're talking about more generally.
So should we open it up for questions? Anyone?
Do you have mics? There's mics in the back too.
Incidentally, if they do get subpoena authority, I'm curious to see how quickly NSA's view on the definition of relevance changes.
Hi, I'm Kathleen McClellan with the Government Accountability Project, and my question is about oversight. We've mentioned, secret courts and secret interpretations of law. We've seen officials lie to Congress. We've seen them mislead Congress. And so from the perspective of doing a legal analysis, whether it's First Amendment or due process, and doing any oversight, is there a concern about what we still do not know about what the government's collecting, and is there a possible solution to that?
I mean, I would say, and I'll also turn over to Julia and Laura, I would say there's very much a concern about what we don't know. I mean, I think some people have alluded to that fairly specifically, right? So Senator Wyden has said, yes, you're finding out a lot, but some of it is still the tip of the iceberg. So especially when you're talking about things like location records. The government isn't telling you anything, and they are still being highly misleading about the information that's coming out. And that has been, I think, one of the fascinating lessons of this summer, right? Is, something comes out, whether it's a memo or a court decision or a letter, and you think, oh my God, this is amazing. And then the next thing comes out, and you realize, oh, I mean, it really is like these platonic shadows. You sort of, and who knows what enormous pieces we're still missing. So I think that's very much a concern. And it's certainly to some extent a concern in terms of suggesting policies, although I think if you're thinking about oversight, transparency, release of information to the public, I think in a lot of ways those stand regardless of whether there's more information that's going to come out. But I think absolutely there's more that we don't know, and I think that's an incredibly important piece of this and thinking more deeply about it.
So just a couple comments about that. I think there is a lot we don't know because Fisk is telling us there's a lot you don't know. In the opinions, they say in similarly situated programs, they say, in these other programs, and there are all these references, veiled references to, well, we know that this is the logic we adopted in redact, okay, right? So we know there are other programs, under bulk collection, telephony metadata, and one can imagine email, internet IP protocol address. I mean, you can imagine other things, financial records, as a thought experiment. There are lots of things that would be very helpful. And with the relevance standard, Julian mentioned that all telephone calls are relevant to investigations, right? So as though it's a category, right, to counterterrorism investigations. Well, so would all bank records be relevant to all counterterrorism investigations. So would all internet IP addresses and protocol, so session times, right? That would all be relevant to counterterrorism investigations. So I don't think it's that hard to extrapolate. But what's interesting to me, so we just had this week, or last week, I guess, the Senate Judiciary Committee hearing, and I testified at that hearing, and the panel before me was General Alexander, and when he was asked by a senator, aside from PRISM, what other programs are under Section 702, he said, well, PRISM is the program that you know about under Section 702, and that section handles electronic communications intercepts. And then he went on to give the legal kind of what that section does, not answering the question at all. The senator did not follow up with a question to say you didn't answer. Very few of the senators actually followed up when the answers weren't given. Now, part of that might be because this is classified information. In fact, that's probably all of what it is, in which case there should be that kind of access behind closed doors where they can have a frank and open conversation. In my view, some things should not be made public, and they should be able to have these conversations. Whether those are occurring or not, I don't know, right? Because I don't have access to that. I'm not sure the extent to which the other programs under 702 are being discussed behind closed doors with the Senate or with the House representatives or not. I will add to that I'm concerned that Congress has really tied Fisk's hands in some ways. So under Section 215, the legislation says Fisk shall grant an order when certain criteria are met, and those criteria tend to be fairly broad. So the fact that Fisk grants 100% of the requests that come before it shouldn't be surprising to us because Congress has tied their hands, right? And so there are other ways we think about oversight where people go before Congress and tell them what they're doing in their agencies, but Congress also has a duty to ensure that the legislation itself allows other bodies to perform the oversight that they need, and whether that means more resources for PCLOB, whether it means making sure that Fisk can inquire below the line and look and see what's happening, whether it means appointing a technology expert so that the court Fisk doesn't have to rely on the NSA for the technologies, whether it means having the Senate have technology experts that come in, or PCLOB have technology experts that understand the technologies. They have a responsibility to do that to ensure that whatever oversight mechanisms are put into place are effective.
I think the top thing on my wish list certainly would be, so Glenn, if you're listening, the opinion referenced in the Egan opinion that Laura mentioned, which is almost certainly the pen register trap and trace authority being used to bulk collect internet metadata. We believe that particular incarnation of the program ended in 2011, but for a whole bunch of reasons, internet metadata is potentially even more sensitive and revealing than phone metadata. For a bunch of other technical reasons, the application of Smith v. Maryland to sort of provide a legal rationale for acquisition of that off the backbone is way, way, way more questionable. So I'd be interested in seeing that. Failing that, though, I knew there are sort of ongoing OIG reports being prepared on, I think, 215 again, but also for the first time on the 214 Pen Register Trap and Trace Authority. So sometime soon we'll probably learn something about that.
More questions? Where are the microphones? She's coming over.
Yes, I'm from Maryland, and unfortunately, people should not forget the role of Governor O'Malley in weakening Senator Jamie Raskin's law, trying to rein in the state police, and unfortunately, the majority in the legislature passed the weaker version. I would like to see, at some point, you focus on what I would characterize as the failures, because just about every incident, the Boston bombing, the VA psychiatrist shootings, all of those individuals were on the radar screen of the intelligence community, and they have not been held accountable. Napolitano herself was not held accountable when the day after the underwear bomber was apprehended by the passengers, even though his father had supposedly gone to the U.S. Embassy in Nigeria to warn about his son. She said the system worked. So the lack of accountability, to me, is very troubling, and I would like to see, because the media, for the most part, are not. They're just very cavalierly dismissing these failures, which I think would then, or should be held up against the amount of data they're collecting that is, in fact, possibly preventing them from seeing what's in front of them when it is in front of them. And my second question has to do with former Senator Mike Gravel. He said when he read the Pentagon Papers into the congressional record, that automatically declassified them. So should Wyden have more courage? Should we disparage him and some of the others for just hinting but not having the courage to use the tools they have?
Right.
Thank you. And I guess my last point is the incident of Berlin Mayor Calvo, where the agent sat and watched him walk his dogs and then knocked his door down, murdered his dogs, handcuffed him and his mother-in-law all over a box of marijuana mistakenly delivered to his front porch. They've never been held accountable. That's Berlin, Maryland.
That's a lot of questions.
Well, so I think I'll pick and choose, although you've raised a number of important issues. I suppose the one that struck me especially was your question about whether Senator Wyden should have read some of this into the record. This was something that I thought about. I will call out my husband, who's here, who used to work for the House of Representatives and who knows much more than I do about the speech and debate clause. And so we had a conversation about whether could any senator or representative basically come to the floor, read an information, be absolutely protected by the clause. That is a question, frankly, that I will leave to legal experts who actually know that very specific area of the Constitution better than I do. I certainly don't have it in me to criticize somebody like Senator Wyden, who I think has been absolutely one of the strongest and most vocal advocates on this issue. I think has repeatedly sort of gone to the edge of what he could say. Certainly he, Senator Udall. Are there other things that could be done under a strict reading of the Constitution? Potentially. But I do think that there's certainly at least some in the Senate and one or two in the House who have really made very, very strong efforts to sort of raise the flag about some of these issues.
So I'd like to touch on something that that's kind of in the background of your questions, which is the role of contractors. So Snowden, his security clearance was done by a contractor, and he was a contractor. The shooting that we had at the Navy Yard, his security clearance was done by a contractor, and he was a contractor. We have a number of issues that have come up lately that raise the question of the extent to which contractors have become embedded in our national security infrastructure. So earlier I referenced the state secrets issue, where a number of contractors have used what used to be an executive privilege, and it's become a form of private indemnity, where contractors are able to get away with all sorts of things. And the way they do it is when a suit is brought against a contractor, they say state secrets because we're dealing with very sensitive areas of the law. And then the government initially is very conservative, doesn't tend to intervene in lawsuits, but then they threaten to air the dirty laundry to embarrass the government or to show things that are going on. The government then intervenes, and it's a form of gray mail that we're starting to see. And we don't have the same mechanisms that we had, that we now have, for instance, for SEPA. If the government wanted to bring a suit previously for a spy, they couldn't introduce classified information at trial, and so we passed legislation to allow them to do that. We don't have an equivalent to bring contractors to be held to account for things that they do when state secrets types issues are on the line or might actually interfere in a suit. So I think that we actually do need new legislation to allow these kinds of suits to move forward, to allow contractors to be held accountable, and certainly contractors that are being used for security clearance purposes. This idea, I know that right now the DOJ is investigating them because they basically had these expedient requests where they would force through security clearances without looking too deeply into each particular case. And I think a really important side of all of this is to tighten our U.S. national security, is to be much more careful about individuals who are engaged with that apparatus in its operation day to day, whether the issue be security clearances, mental stability, access to information, trusted partner, technical expertise, or being held accountable for everything from personal injury and wrongful death to patent disputes and environmental degradation.
Oh, sorry. Do you want to say something?
Two quick things. So one, Senator Wyden, I think so he's speaking at CATA tomorrow. I suppose it'd be awkward if I were to, agree that he should be condemned. But I do in fact think that the speech and debate clause, whatever else it might protect him from, doesn't guarantee him a chair on the Intelligence Committee. I think we're just sort of better off with him raising the red flags he feels he can than sort of committing harakiri and sort of dumping it all in one go. As for, I just want to sort of stop and note that you talked about failures. I wanted to question that because I think implicit in that is this idea that, my God, there's all this data, and if in hindsight, knowing there was an event, we can look back and say, well, these guys were on the radar, why didn't they put all these pieces together? Sort of ignores the fact that ex ante, before there's the event, there's thousands of people on the radar in some sense. There's thousands of people that someone has said, this guy seems really radical and like he may be a little nuts. And so the assumption, I guess, is, well, but if only you had the right algorithm and enough data, you could prospectively weed through those people and not just send agents to every person who says something angry on the internet, but actually figure out who the dangerous people are. And I think that's actually the dangerous premise, the thing that drives ever more data collection after every failure. Maybe they're not failures. Maybe not every bad event is actually predictable.
I think that's an incredibly important point. I think that ties into all of this. I think that's really well said. And the one other thing I was going to add, sort of thinking back again about Senator Wyden and others in his position, is that obviously when Senator Gravel read the Pentagon Papers into the record, that was not a riskless proposition. But we are in an atmosphere right now where we know that the government is essentially conducting an unprecedented war on whistleblowers. They have gone after journalists' records in a way that seems to be unprecedented. And so I think it's not unreasonable. You think about General Petraeus, right? This incredible sort of electronic dragnet that was launched. And so I think it's not unreasonable to be kind of especially cognizant of those risks, of the resources at hand, both in terms of manpower and technological resources, in terms of thinking about whether to take that kind of risk, and the risk to, I agree, not just having somebody stay on an intelligence committee, but a risk to one's sort of personal life writ large.
And also, I just want to add in Rachel's defense, there's actually a very good section in here called Drowning in Data about that the issue of whether this actually works, right? Having so much data and the effectiveness of it.
Yes, yeah, no, absolutely, which is something I'd sort of mentioned at the beginning but hadn't gone into much detail on, which is that I think it had come up in the context of the underwear bomber, but that really in sort of time after time when there are expert reviews, the underwear bomber, the Fort Hood shootings, things like that, that over and over again, one of the things that comes up is that often there was too much information in the system. And that really did hinder kind of accurate analysis. And then I think also going along with Julian's point.
Question in the front here.
Yes. Yeah.
This is a question directed to Rachel. You used the phrase public oversight, which is really a big phrase, and if you could adumbrate, that would be great. Whether you mean that oversight just takes place in the public sphere, or whether you mean that those bodies that are supposed to be conducting oversight are doing so in a public way, or whether you mean that it can become a kind of general political adversarial proceeding, the way things do in the US, or what do you mean by the phrase public oversight?
So when I was using the phrase public oversight, I was sort of not exactly contrasting that with, I guess, juxtaposing it again against things like congressional oversight, oversight from an independent board, oversight from the Foreign Intelligence Surveillance Court. And what I meant was the oversight that the public as a whole could exercise, not meaning so much that necessarily the public could go to an agency and say, we think you need to be doing something differently, but that the more information is transparent, the more information is available to the public, the more information is actually easy for the public to get to and understand, the more the public can impose pressure, whether that's in direct or indirect ways. So direct pressure on an agency, or pressure on their elected representative to make certain changes. I will say one of the most interesting things in doing the research for this report is that it largely draws on public sources. And by that, I mean really a combination of things. So there's amazing work that investigative journalists have done. There's FOIA litigation that groups like the ACLU and others have done that have brought really important documents into the public sphere. There are certainly FOIA requests that we did. There are things like the Inspector General reports. There are these this declassified information. But by and large, all of it is in the public sphere. And yet it still took huge amounts of unearthing to kind of put it together and figure out which pieces related to which ones. And these are all documents that really relate to what the government is doing with our information. So some way that information is more transparent and more sort of easily combinable with each other, so that this information, I think, is easier to understand for the public as a whole. That's what I think of in terms of public oversight.
Laura, you have a follow-up?
Yeah, I actually just want to add that this is an instance of public oversight to me, this report, in the best possible sense. So, I mean, I follow this stuff pretty full-time, and I learned from what you put together. So I think this is actually really important to have this kind of information available to people. And so I really applaud Rachel and the Brennan Center for doing this, because it's incredible, especially things like border searches, threat assessments that aren't in the news, aren't like the latest, Snowden dump and everybody responding to it, but are really bringing attention to kind of the systemic issues that we're seeing across the board, not just in national security, but in law enforcement and in other areas. So, so to me, this is actually, a form of public oversight. And so I thank you for doing this. I think it's actually very helpful to see it.
Yeah, I want to second that. As a journalist who writes about this full time, I learned a lot, and I was really hitting myself over the head for missing the chicken incident. Do you have a question? Yeah.
This is for Laura. Laura, you mentioned the 3 Inspector General reports on national security letters and exigent letters as examples of effective oversight. But in fact, there was no substantive change made in the subsequent Patriot Act reauthorizations, and the only substantive change made on the whole program was that a secret OLC opinion was written making the Post-it notes legal. But there were also 2 Section 215 reports issued that actually masked the scope of the problems. And overall, the 5 reports, it was shocking to us that 50,000 NSLs a year were going out, but it hid the fact that there were hundreds of millions of people's metadata being collected under these programs. So how does that alter, this hindsight alter what those IG reports were as far as whether they were effective oversight or actually giving us the illusion of effective oversight?
So my thoughts on this are that the NSL IG reports were initially aimed at Barton Gellman's 30,000, NSLs. And when they actually came out and said, actually, it's 50,000, 60,000 exigent letters, Post-it notes, and then the next one followed up and said, well, you still haven't fixed this problem. And by the way, there's this issue now that we're focusing on. And then they had an interim report that came out. To me, that was actually effective oversight. That made that information public, transparent. Congress was aware of it. They then had to answer for it, even if they had been told closed doors, hey, we're posting, we're putting Post-its on each other's computers and getting information about U.S. citizens this way. If they knew that closed doors, it made it public and allowed them then to address this and to speak about this publicly. So if you consider the gag orders, right, under NSLs that couldn't be challenged, the ALA, Ginsburg actually ruled that because Doe, right, in the case, because the American Library Association could speak to Congress, Doe, anybody served with an NSL was gagged from actually talking about the process. So those IG reports, I think, played a very important role in light of the other ways in which Congress's hands were tied, right? They couldn't discuss it publicly if they knew anything behind closed doors. So I actually think that they were good instances of actually being able to see what was happening and make that information available. And in this instance, it went way beyond what the media itself was able, what the Fourth Estate could essentially dig up in terms of finding out what was happening. Now, whether Congress then put into place sufficient strictures, well, that's a transfer of responsibility. That then goes to Congress to figure out what to do about it. And I think that you're right, that there are ways that Congress could do this much more effectively, that the 5 authorities that NSLs are issued under are extremely broad, that any one letter can get millions of bits of information, and as Rachel points out in the report, it can then be kept for decades and mined for further information. We have the Attorney General guidelines that actually require information to be obtained to be kept and mined for further information. These are questions for Congress to then step in on, and there I think the Madisonian check is the only one that we have.
Wow.
It has been really interesting to go back to that second 215 IG report, just at all these long redacted blocks from earlier where these numbers do not include the blah, and you suddenly go, it all makes sense now. I will say, the IG reports on NSLs have been super, super useful, but the first exigent letters were issued in 2003. And the report where we actually understood the scope of the problem, which had basically been reined in about 2 years previous, was 2010. Now, that report was very useful and informative, but when your model of effective oversight is, we figured out there was a problem after we had illegal collection of information for 3 years, well, I mean, that is a low expectations version of effectiveness.
Not to mention, I just had to point out that, for journalists who sometimes start the investigation, right? But our sources are drying up because they're afraid that every way they possibly could communicate with us is monitored and they're going to be put in jail. And so the ability for us to trigger these kinds of investigations it's becoming precarious. One more question I think we have time for.
Thank you. George Jameson. Good discussion. The couple of things jump out at me that I'd like to ask about. One is, when we talk about this massive or even narrowly focused collection, we really need to focus on what's the purpose, what's the goal. And sometimes on both sides we lose track of what's the purpose of the collection, what's the purpose of the retention. And so the question I would ask is your focus, or should the focus be on the collection and retention per se, or is it more on the use? And as part of the answer to that question, could you address why the focus on retaining it or using it only for criminal purposes, when perhaps there may be a lot of other purposes, maybe a public health and safety, that doesn't have anything to do with the purpose for which it's collected? And I would say that the difficulty in dismissing something like that and saying, well, if it's not worthy of terrorist review, get rid of it, why would you need it, is that at the end of the day, it might be useful for something. And as Laura and Julian, in somewhat different contexts, talked about the concern about a mistake. People make mistakes in lives and they don't want that to be on the record. Our society is such that government employees can't make mistakes. If you miss something, it's a mistake. If you have the information and you don't use it, and you only find out about it when it's too late, it's a mistake. Doctors can make mistakes, and not every mistake is medical malpractice. And I wonder if we don't need some sort of a standard that protects employees from making the honest kinds of mistakes for something that really isn't a failure. But my basic question has to do with the collection and retention versus the use.
Sure. It's a good question, and I appreciate your being here and also raising the question. I have a couple thoughts on that. I think the first is that it's almost impossible to disentangle the retention and the use question, in part because of what we were talking about before, sort of the inevitable slippage in terms of how information is used. So conceivably, one could say you're retaining all this information, you're only using it for limited purposes. We've talked about some of the harms that we think even just the sheer retention of information could cause in terms of First Amendment chills, sort of the notion of a democracy, things like that. But even if we sort of set those aside and say we could impose these very, very, very narrow limitations on use, I think to some extent I don't trust that those limitations would hold, just kind of taking that at face value. I do think that is always the inclination with information that's held, and Julian sort of spoke about this too, that not only once you have it is there an aversion to giving it up, but I think also once you have it there's a temptation to use it for more and more purposes that seem reasonable, that seem legitimate, that are sort of useful to the polity as a whole potentially, but don't take into account the harm to the individual, or the second thing that you raised, which is the use it was originally gathered for. So this is one of the things that the Privacy Act speaks to, is the uses that information is originally used for, and not kind of farming it out for lots of other uses, at the very least without some public notice. And I talk about how I don't think the notice provisions do a whole lot. But there has been this decision that is kind of something fundamental, that when an agency, when a part of the government collects information, that it should be defining the uses that it's gathering it for then, and if it's going to use it for other purposes, that there needs to be something more than just, well, it seemed like it would be useful for this as well. And then the third piece, I think, is a question of who makes that determination. So you mentioned public health purposes. And I could certainly envision, public health emergencies, crises where it would seem important to use information gathered for one purpose, for that, who knows, if it's notifying people, if it's a quarantine. At the very least, there are going to be countervailing interests, people's privacy, information about their health or about their person that might be revealed to others, whether it's others within an agency, somebody with another agency, the public as a whole. But then I think you do have a question of who's making that determination and on what grounds. So those would be my thoughts on that. I don't know if other people
I mean,
wanna
that is
add.
sort of the question of the information age, right? I mean, this is what Google
Right.
argues, right? We take everything and we're going to come up with awesome new things for you and you're going to love them and trust us. And, they do come up with a lot of awesome things. And so there is some truth to that, right? Where the big data sometimes benefits us. On the other hand, the fact that my phone is transmitting where I'm at so they can do better traffic reports, I'm their traffic reporter. Like, do I get paid for this? So there's like all sorts of issues with this. And fundamentally is the same issue the government is also Googling. They're like, well, we might want this for something else. And, it's hard to argue against that something else that doesn't exist.
So
Right.
this is David Brin's point in A Transparent Society, where he says, we used to live in villages where everybody knew what was happening and you knew everything. And then we went through industrialization where it's all depersonalized. And now we're going back to where everybody knows everything. The problem is actually we know everything everybody's doing. We just don't know what the government's doing. And that's a power disparity. And that's a problem because you can see everything else going on, but you can't see into the inner workings of governments. And that's where the power base is consolidated. So actually, I'd like to respond to George's point. So actually, I've heard that a number of defense attorneys are now subpoenaing records from NSA to help exculpate their clients in various cases. They're actually trying to use it for criminal purposes, for criminal records purposes. And I guess my response to this is threefold. First is the point that Rachel raised, which is about the slippage. So think about COINTELPRO. It started as a program to stop or to monitor individuals traveling to Cuba, right, back and forth to Cuba. By the time it ended, it had been expanded to the NAACP, civil rights individuals, Martin Luther King, protesters, anti-war protesters, suspected drug dealers, criminal activity. It had been expanded to the KKK. It had just radically expanded to include everybody. And this comes to the question of whether usefulness qua usefulness is ever a sufficient justification. And I think that it is not because of the implications for privacy, associational rights, free speech, democratic debate, all of these risks that are entailed in that something that's collected for one purpose should not then be used for myriad other purposes that occur. The second point I would make is that I have heard this argument that individuals who are put in these positions, it is unfair, right? We have people who we put into positions and we expect 100% success rate, right? We expect that the director of NSA, that there will be no attacks on US soil. And if there is, who gets called before Congress, right? He gets called before Congress. He is excoriated. He is, just intimidated. He is told he fell down on the duty. He takes full responsibility for that, as do the general counsels of these different agencies. The problem with this argument is that I understand that this is an unreasonable expectation that is placed on them by society, and that needs to be dealt with. But these people also swear an oath to the Constitution and to uphold the Constitution. And in crossing those lines to the full extent of their abilities, there also is, despite Marbury, a responsibility of all branches to ensure that what they're doing is well within constitutional bounds. And I think that we expect them to cross those lines, and we hold them to account if they don't cross those lines, if anything bad happens. And it is an unfortunate aspect, and something we need to think about is the extent to which witch hunts following something occurring really are beneficial long-term for people that are putting their best effort in and really trying to protect the country against national security threats. So that would be the second point. The third point and final one is this idea of it being useful for other purposes. I just would raise a seizure question here under the Fourth Amendment. So that you have a possessory interest in information that you share with an individual agency. So if or with an individual corporate entity. So if I am contracting with my doctor to deal with a heart problem, right, then I have a possessory interest in that information that is going back and forth to my doctor. The government taking that information is a form of a seizure, I would say. And using as a way of narrowing our scope of these authorities the purpose for which that information was collected and narrowing in on that, I think is actually a very promising way to move forward, to look at what the possessory interests are that are being interrupted or interfered with by government acquisition of that information, and may in some sense help to tailor the back-end analysis of that towards issues that are more appropriate for the collection of that information. So if our concern is yellow fever breaking out in Louisiana, say in New Orleans, then having a health monitoring system where you have contractually agreed that this information will be used to help stop outbreaks, so DHS starts monitoring these in order to do this, or HHS in this case, then that seems to me to be entirely appropriate. But if you then have NSA coming in and saying, we want to know everything about this information, and combining all biometric, biographic, and electronic, intercept communication about this individual, that's a very different kind of a haystack that it's trying to build, and one that is very different than the purpose for which you gave this information to a third-party provider.
I think we should wrap it up. I think we should just say that was a great, there's a great quote at the beginning that we should end with, which is the dictatorship of dossiers, which is, I can't find it at the moment. But anyways, it's sort of what you're describing is this sort of like, is there a potential for a dictatorship of dossiers?
Right, and this, I'll speak to this. It was a quote during the discussions that the Senate had over the Privacy Act, in fact, and Professor Arthur Miller, so I can't do the quote exactly, but basically said that the concern has always been that a dictatorship comes with hobnailed boots, but the concern that we're going to have is a dictatorship of dossiers.
Right. And you've done a great job of outlining it, so thank you very much.
Thank you.
Thanks for everyone staying. Well, great questions.
Thank you.